When it comes to your retirement accounts, you probably think your beneficiary form tells the whole story. But with 401ks and other ERISA plans, there's one rule that can override your choices. And in one case, it cost a family $3 million.
We're back on Your Retirement Elevated. Walter Storholt alongside Scott Dugan, a financial advisor and the co-founder of Elevated Retirement Group, serving clients all across the country. Welcome to the episode and to our channel. If you're new to the YouTube channel, by the way, don't forget to hit like on today's video and subscribe so you don't miss future conversations and episodes as well. And you'll get unique ones like today's. Scott, this might be the first, before we got into YouTube, we were doing audio podcasts for years before this. I think this is the first time we've ever had a full episode dedicated to ERISA. So I'm looking forward to this one. I know you're going to kind of start things off with a story here so we can kind of understand what's going on. But you caught my attention with the $3 million somebody kind of was cost with this mistake.
It was a big one. I read this. I'm a follower of Ed Slott. He's the America's IRA expert. And I heard this story through them a while back. And I thought, this is worth sharing because in our process, we have the 5 areas of planning, and estate planning is one of them. We have an estate planning firm we work with that takes care of that for our clients. And we always do a beneficiary review. And it's amazing the things that we find when we review those, because sometimes we've made choices way back in the day and we just haven't updated them. So I thought this one was an actual case. So all this information is out there. So we're not divulging anything. It's all public knowledge. But this is a case of a gentleman. His name was Alvin Martinez. So he was a longtime Entergy employee, and he had $3 million in his 401k plan. And a 401k is an ERISA plan. All right. So it's different than an IRA. ERISA oversees 401ks. 403Bs, 457s, things like that. So after his wife passed away, he named his 4 children as the beneficiaries. So you can understand, wife passes away, he's got 4 kids. I want this money to go to my children.
Logical, right?
Very logical. Mm-hmm. Later, Mr. Martinez remarried, but never updated his beneficiary designation form. So quarterly statements that came out still showed that the kids were his beneficiaries. But when he passed away in 2021, the $3 million went to his second wife, not the children.
Oh, okay.
And the sad thing is the court upheld the plan's decision, citing the ERISA's spousal protection rules were at play.
Interesting, because that goes counter, Scott, to kind of what I've always heard, where beneficiary designations override everything else is sort of the buzzword phrase, I guess, I've heard over the years.
And that is true in many, many cases. But in this situation where the ERISA plan, the 401k, even though he had that beneficiary, the rule says, hey, your spouse is going to be the beneficiary, and there's things you have to do to make sure your wishes are met.
Interesting. So, this is news to me, right? And I imagine to a lot of people.
And it's making the buzz. I say when Ed Slott's team put this out, I'm like, I remember hearing about this, but I don't think people talk about it enough. And I think that blanket statement of beneficiary forms trump everything. Well, they don't in this case. And that's the court.
And it's not like we're talking about some obscure plan here, Scott. We're talking about 401ks. I mean, pretty common.
Correct. So the ERISA spousal beneficiary protection rule applies to employer-sponsored retirement plans, ERISA, which again, 401k, 403b, things like that.
Okay.
By default, the surviving spouse must receive the balance in that 401k. To name someone else, the spouse must sign a written waiver.
Wow. Okay.
Giving up their rights. All right. So that's, again, this is in this particular ERISA 401k plan. Now, to make it even more complicated.
401ks, right? 403B.
403Bs, 457 plans.
Okay. Yeah.
IRAs are different.
Okay.
So when people say, like you said, beneficiary forms, those trump other things like a will or a trust. The thing is, beneficiary forms generally do control. There's no automatic spousal rights under the federal law. Some states have community property rules that may apply. But again, you've got to understand what you hold, what type of plan you have. And when you're talking about your estate distribution, you've got to understand what your options are and what the rules are that are governing that. We did an episode earlier talking about, pulling money out before 59 and a half was a 10% penalty unless you're 55 and leave money in your 401k, and you can take that out without 10% penalty. Again, it's the devil's in the details. You've got to understand these rules and how they may affect you. And this family obviously suffered substantial because Mr. Martinez's wishes were not met through no fault of his own. It's just he didn't understand the laws. So the lessons learned here is that in ERISA plans, spouse is the first in line unless they consent otherwise. Sign that waiver.
And you've got to have the consent, right?
So you've got to have it.
This can't be underhanded by any means.
Correct. So life changes equal beneficiary reviews. When someone passes away, there's a divorce, remarriage, new children. Those are all situations where we say, hey, we need to go through the beneficiaries. I know the team just completed a very large project in our office that they do every year, is we reviewed every single beneficiary for every client on every account that we have. Physically put eyes on the forms and made sure everything matched. And now when we go through our strategic planning meetings here at the end of the year, we know that there's some things that we need to go through, or if it was immediate, we reached out to the clients to do that. But that's a proactive thing that we do because not everybody remembers, oh gosh, we should do this. So in that situation, Mr. Martinez was looking at the statements and said, had the right beneficiaries on it. But so you can't go by what's on the quarterly statements. That may not reflect the true legal outcome that is going to happen. And again, for IRAs, designations usually stick, but they still need to be reviewed on a periodic basis.
Is your retirement strategy working as hard as you are? Get the answers you deserve with Elevated Retirement Group's information-packed toolkit. Inside, you'll get Scott's book, Exceptional Retirement, along with essential insights covering the 5 key areas of retirement planning, strategies to keep more of your hard-earned money, and how to choose your winning retirement team. Take control of your retirement today. Click the link in today's show description to claim your toolkit at no cost to you.
Yeah, you can still have issues pop up, maybe not this specific rule, but man, if it's appearing on the statements showing my beneficiaries, I sure do expect that to be the outcome. So this one's concerning to realize that it's that easy to make a misstep, I guess.
Yep. So practical steps for the viewers. Number 1, review all beneficiary designations regularly, especially after a marriage or a remarriage. 2, know the difference between an ERISA plan and an IRA and the rules that follow them. 3, coordinate all those with your estate plan. 4, if you're remarried and want your kids from a prior marriage to inherit, get spousal consent in writing for your 401ks and ERISA plans. And finally, number 5, work with a fiduciary advisor to avoid these costly surprises. So if you think about this, the Martinez case is a $3 million reminder that when it comes to 401ks, ERISA rules can override your beneficiary forms. For IRAs, your designations usually stand, but only if you keep them updated. So I would tell our listeners, schedule a retirement beneficiary review with your professional or with our team so they can walk through our process to make sure you're not going to be the subject of one of these YouTube episodes where they made a $3 million mistake.
Usually our stories here on the show, we change the names to protect the innocent, but as Scott mentioned, this is kind of a public story that's out there. So we're not betraying any confidences here with this story by any means, but good to at least still kind of cover that, Scott, so folks know that they might be an example on a YouTube show, but no names will be shared for sure. Yep. Usually they're examples of how people turned out better than they thought they would end up, not quite like this. If you go to get one of those reviews, you're asking your advisor for details details on how to assess your beneficiaries, how to make sure that they're set up right, not only on the IRA, but also your ERISA plans. And they look at you like a deer in the headlights, or try to underplay that, or don't really have that kind of process, it might be a sign that you're not working with an advisory team that does full comprehensive financial and retirement planning. So if you'd like to engage in that kind of planning with someone like Scott and his team at Elevated Retirement Group, again, just click the link in the description of today's show and you can schedule that time to visit. It's really easy. You'll just have an introductory discovery call, either in the office or via Zoom, whatever's comfortable for you. And then you can go from there to see if you're a good fit to work with one another and dive deeper into the planning process and reviewing, very importantly, these beneficiary designations. Scott, thanks for the help. Appreciate you bringing this story to our attention. I'm kind of blown away that that's kind of been a thing for a while, and it's not known by a lot of people. It's that other assumption that gets us into trouble. So thanks for bringing it to the light.
Absolutely. My pleasure.
All right. We'll see everybody next time right back here on Your Retirement Elevated.
This video has been prepared for educational and marketing purposes only. The information in this video is general in nature, does not constitute personalized investment advice, and does not provide a complete analysis of the subjects discussed. All investments involve risk, and different types of investments involve varying degrees of risk. There can be no assurance that any specific investment strategy will be profitable or suitable to you. Additionally, although information presented in this video is believed to be factual and up to date, we do not guarantee its accuracy. You should consult an attorney or tax professional regarding your specific legal or tax situation and should consult a professional advisor before implementing any of the strategies mentioned in this video. Investment advisory services are offered through Elevated Capital Advisors LLC, an SEC-registered investment advisor affiliated with Elevated Retirement Group LLC. Registration as an investment advisor does not constitute an endorsement of Elevated Capital Advisors LLC by securities regulators, nor does it indicate that the firm has attained a particular level of skill or ability. Insurance advice and products may be offered by a third-party insurance producer, which may be affiliated with Elevated Retirement Group LLC and Elevated Capital Advisors LLC. Walter Storholt and Third Wheel Media LLC receive compensation for their assistance in preparing and hosting this video.